Mr. Chief Justice, Associate Justices, and may it please the Court. My name is Ash Dadwani, and I represent the respondent on the merits of their Fourth Amendment issue, whereas my co-counsel, Gabriella Epley, represent the respondent on the merits of their Sixth Amendment issue. There are two major points that this Court should focus on today. One, that the minimal expectation of privacy that was established in Carpenter v. United States was not violated in Mr. Bronner's case. And two, obtaining a burner phone to hide your identity from the government is not an unreasonable exhibition of privacy that this Court should accept or see as reasonable. For January 16, 2016, the petitioner's counsels argued that when the task force had obtained information from the Olympus Cellular of every time Mr. Bronner was within 5 miles of these 10 specific locations, the task force violated the CSLI standard that was established in Carpenter v. United States. However, the information that was obtained in Carpenter v. United States and the way it was obtained is not analogous to the case in front of us. In Carpenter, Justice Roberts highlighted the fact that it was a retrospective data, and the individuals or the people did not expect the government to catalog and to track every single movement.
Counsel, I have a question. There were 3 warrantless searches, right?
Yes, Your Honor.
Do we have to evaluate, or should we be evaluating each one independently, or are we looking at all 3 as a group?
Your Honor, we argue that it should be evaluated independently, but either way, all 3 of the warrantless seizures of evidence were not a violation of Mr. Bronner's Fourth Amendment rights.
All right, if that's true, then on the first 2, which were roughly a month before the Super Bowl, what justified doing those warrantlessly? Well, in other words, they'd gotten 4 or 5 warrants already. They knew how to do it. There was plenty of time. What was the emergency? What's the justification doing with those first 2 without a warrant?
There was no emergency. The respondent argues that there was no need to get a search warrant. It was not that the task force had failed, but they did not need to based on the standards that this Court has established in previous cases. On January 16th, the data that was collected was real time, and it is very important to highlight that it was real time and not retrospective.
Well, you say there's no emergency, but they approached the cell phone provider, what the name of it is, and they tell those people, it's important we get this information right away. You know, that we, for whatever reason, we don't have a warrant, you've got to give us this stuff right away because the evidence may evaporate or there's an emergency situation or something like that. What's the justification for doing this without a warrant?
Again, Your Honor, yes, the task force did say it was time of the essence, and it was 1 month before they had to obtain all the information on human trafficking, but it was not that they needed, it was not more of an emergency, but it was that they did not need to obtain a warrant, that it was not required by the law for them based on the type of information that they were collecting. For example, in Knox v. United States, this Court ruled that the tracking device that was used and covered in chloroform was allowed because the information it revealed was very limited and it was exposed for anyone to see. Similarly, in this case, the 10 locations that we're looking at and the movements of Mr. Bronner in real time, they were exposed for any general individual to see, which is why when we look at Knox v. United States and Carpenter v. United States, the 13,000 pings that were collected in Carpenter v. United States, or the fact that the government was able to track the movements of Mr. Carpenter in the past that they could not have in present time, indicates that that is not the same type of information that was used against Mr. Bronner. Instead, since the information was real time, Mr. Bronner had shown no expectation of privacy in the real time data.
Humor me on this one. You're not going to agree with me, but I want you to assume that the premise of my prior questions was correct. The first 2 warrantless searches were improper because there was ample opportunity, for whatever reason, there was ample opportunity to get a warrant. Let's assume those first 2 were improper. All right, now we have the third one, which is the day of the Super Bowl. Now, do we evaluate the third one separately? And can it stand on its own? Or is it basically the result of poisoned fruit because we got there on the back of 2 what we've determined to be improper searches? Or can the third one stand on its own if the first 2 are considered improper?
Your Honor, the third one can stand on its own, and it is not an improper, like it's not the poison of the fruit. There, again, in the third one, they did not need to obtain a warrant based on the information it revealed. Furthermore, if this Court does not buy that argument and does not believe that the task force did not need need to obtain a warrant. There definitely was an emergency of providing aid that states that the task force was right in their actions.
Wait a minute, did you just say that there was an emergency for providing aid?
Yes, Your Honor.
To who?
To the human trafficking victims.
Like, couldn't that argument be made in any crime, that there's always an emergency to provide aid to the potential victim of a crime?
Your Honor,
You're just doing away with the concept of emergency by saying we're investigating a crime.
Your Honor, there are some limitations that this court has established to when the task force or when the government is providing emergency aid. And on February 7th, 2016, the day of the Super Bowl, it was imperative for this task force that they had investigated that the information that they had collected for the past year and a half, it was to provide aid and to prevent this human trafficking. And in that case, they were providing aid to all those victims that would have been subjected to human trafficking.
Counsel, that's not the argument that was made by the court below. The court below said the law enforcement officials in Olympus reasonably believed that evidence would be destroyed. It wasn't an emergency by providing aid, it was that the evidence was going to be destroyed.
Your Honor, based on the records that the Carpenter of the United States has stated, and based on Appendix 1, it is important to acknowledge that the evidence that against Mr. Bronner with burner phones or cell phone records, they are held in with cell phone sites or cell phone companies for up to a year. So it would be unreasonable for the respondent to argue that evidence would be destroyed when the Olympus Cellular would have access to evidence for a whole year. On February 3rd,
You just argued that there's no emergency for anything being destroyed.
yes, Your Honor, it's providing aid to.
If there was no emergency, then isn't a warrant going to be required?
Your Honor, there's 3 types of emergency: destruction of evidence, providing emergency aid, and then hot pursuit. The respondent is arguing that there was no hot pursuit, there was no destruction of evidence, but it was to provide emergency aid to potential victims of human trafficking. And based on that information, there was no need for task force to obtain a warrant. On February 3rd and February 7th, the petitioner's counsels argued that because Mr. Bronner had obtained a burner phone, that he was trying to decouple his identity, and which is why this court should recognize his exhibition of privacy as reasonable. However, consistently, this court has
Counsel,
not.
I've heard the term burner phone 20 times already in these arguments. Is there something inherently suspect about the use of a short-term contract phone of the type typically used by individuals who can't afford long-term contracts? And doesn't this put persons of modest means at disadvantage under the law all the time?
A presumption of guilt because of the use of something that only that is within their economic means?
There are multiple reasons why an individual obtains a burner phone, and including one as presumption of guilt can be one of them. However, consistently, this court has not ruled on the device that an individual used to determine whether an individual maintains an expectation of privacy. When we look at United States v. Jones, when we look at Kylo, when we look at when we look at Carpenter v. United States and Smith v. Maryland, it is that individuals maintain an expectation of privacy on the data that was collected and what the data had revealed. In Smith v. Maryland, it was not that the court said that an individual who uses a home phone does not maintain an expectation of privacy in the numbers that they dial, but it said that individuals do not maintain an expectation of privacy in the numbers that they dial. Similarly, even if it was a burner phone, even if it was a cell phone, Mr. Bronner never maintained an expectation of privacy in the numbers that he had dialed. So even if he was trying to decouple his identity, this court has not recognized the devices as reasonable, but what the data had revealed. And that was the argument that the petitioner's counsels offered for February 7th as well. But burner phones should not be recognized reasonable just based on what they can hide or what they can reveal, but it should be based on what data can be revealed and how it impacts an individual on the other hand. Based on these reasons, the January 16th warrantless seizure of evidence was not a violation of Carpenter v. United States because the data collected was real time and exposed for anyone to see. And the February 3rd and February 7th warrantless seizures of evidence were not a violation of Mr. Bronner's expectation of privacy just because he used a burner phone, but it is that it was protected by Smith v. Maryland of this court's decision. For these reasons, today we ask this court to affirm and uphold the decision made by the Supreme Court of State of